Hello again, everyone. I'm John Ray, and welcome back to the Price and Value Journey. So I have published my first book. It's been out now for about 6 months. It's called The Generosity Mindset. More on that later. And in that process, I engaged a trademark attorney, and I had a lot of conversations with her about the wisdom of creating a trademark around the title of the book, but not specifically the title, but the methods and practices of the generosity mindset and trademarking that. There's a difference there we'll get into here a little bit later. But I thought it would be a good idea to talk about that and to talk about how a lot of service providers have intellectual property that it might be wise to protect. And then there are some that have maybe aspects to their business that they think are protected, or they can protect, I should say. They really aren't protectable. So we need to get into the differences of those and the pros and the cons and the return on that. And I can't imagine a better person to talk to about that. And Katie Moore is my attorney. She that handles that for me, and her firm is Katherine Moore Law LLC. And Katie has been an attorney now for quite some time, but here's the thing. She focuses on specifically trademark and intellectual property protection for small businesses, and she is passionate about the fact that many small businesses have intellectual property that they ought to protect. And she's here to talk about that. Katie, welcome.
Thanks so much for having me, John.
Yeah, I'm delighted to have you here and to talk about this. I want to talk a little bit about you, though, because you've got a passion about this that comes early on in your life, right? Your father was an attorney.
That's right.
And that got you really turned on to the practice, not just the practice of law, but IP protection, right?
In particular,
yeah,
yes.
Yeah.
Yes.
So tell that story.
So my dad is an attorney. He practiced in the patent space and in intellectual property and in business. And I like to tell the story that I was the kid who knew to call it a tissue instead of a Kleenex, because Kleenex is a registered trademark. So he'd point out things like that. And so it really was a part of my growing up and something that I am passionate about and that I enjoy thinking about.
Yeah. So let's talk about, and we're talking about service providers here, because so just to be clear, if you turned onto this podcast thinking you're going to hear about the latest technology resource or something like that's not really what we're getting at. We're really addressing service providers that are selling their expertise. And I guess the opening question here is, how do I know when I even need to have this consideration in my mind? How do I know that I need to start thinking about protecting my intellectual property if I'm a service provider?
I think as a service provider starts to build their brand, as they start to create their logo, their tagline, they're out there selling their services, they're creating value and recognition in the community associated with that brand. And it's one of those things that needs to be top of mind really from the beginning.
Okay. But if you're creating value, there's a lot of ways to create value, right? There's creating value in client transformation and client results, right? But that's not what we're talking about here.
No, we're talking
per se.
No, not necessarily. We're talking about the fact that when someone goes to look for you, or when they see your name or your logo on a chamber event, that they connect that with you and with your services in particular.
Okay. So let's get into what we're talking, some specifics about what we're talking about. People get that. So
Sure.
Let's use me as an example, since we can use my mark without having to worry about it, right? The generosity mindset. So you and I talked about the pros and the cons of this, and let's talk about how that conversation unfolded and why I would want to, as I've in that process right now, why I would want to create a mark for the generosity mindset.
So I think it's helpful to first step back and talk about what a trademark or service mark is.
Okay, let's do that.
So that is a word, a logo, a tagline that is used in connection with specific goods or services.
Mm-hmm.
So the generosity mindset used in connection with your consulting services, for example, if that's the brand under which you're going to offer those services, that can be protected. And you can keep other people from trading on your goodwill and reputation and using a name that's confusingly similar.
And we were talking before we came on about what you can and cannot trademark. And one of the things you cannot trademark are what you call descriptive trademarks. Let's talk about what that is.
Sure. So one of the things that we need to be aware of when we're clearing a mark and then moving through the application process is whether there are distinctive terms in that mark or if it's only descriptive of the services. So for example, if you wanted to trademark the pricing consultant for pricing consulting services, that would be a problem because everybody who offers pricing consultant services ought to be able to use those words to describe what it is they do.
Right.
So at that point, we'd have a conversation about perhaps some distinctive term that we could add that would then make it eligible for trademark protection.
So let's give an example there. Would that be something that maybe an accountant with a personality? Would that be, come on, accountants, laugh with me on that. I'm just kidding. Would that be something that you could possibly trademark?
I think so. We'd need to do a search to make sure that there isn't anything similar out there. But yes, an accountant with a personality as a tagline is great. Your accounting firm would be something that we would need to make sure that that's distinctive enough.
So that's descriptive, but it's not so broad is the answer to the question, right? It's not so broad that it would apply to thousands of accountants out there.
Those terms that accountants need to use to describe what it is they do, those can't be protected and prevented from use by others.
Okay. And part of the process here is you talked about do the search. So let's talk about process.
Okay, absolutely. Yeah. So the first step in the process is a conversation about the mark, about its intended use, because trademarks are registered in connection with specific goods or services. For example, with your mark, the generosity mindset, we had to apply in specific categories for protection. You don't get a registration for any use of those words anywhere. So I would talk with the client about their plans, about what they will use the mark in connection with. And then I would run a comprehensive search. I use an algorithm, a third-party search that pulls back records from all 50 states and the territories, from the federal trademark records, and also unregistered users on the internet. So who's out there using a similar mark without the benefit of registration? And from that, I'll put together a recommendations memo and give feedback on whether this is a mark that is worth pursuing, that is possible to protect, and also, very importantly, whether there's somebody else out there that the mark may infringe on.
And your recommendations to me were both, there's the legal side of it, and then there's the business side of it, right?
That's correct.
So let's talk about the distinction between those two.
We need to ensure that we're using the mark in a way that entitles you to registration. So there's certainly practical things that need to be discussed in terms of how will we prove use in connection with the specific services we're claiming in our application. Obtaining the registration is one thing, but also ensuring that the client is comfortable with how this is going to be used in their business and that they feel like this brand used in these ways is going to bring value.
Yeah, and I guess where I'm going with that is the legal side of it is that, and we just reviewed this in my case, there are all these different classes that you have to either apply for or don't apply for. If you apply for a class, you have to show that you're using the mark within the parameters of that class.
That's right, with the things that you've claimed in your application.
Let's give folks a sense of the scope here. So, like, how many different classes are there?
There are 45 with the federal office.
Okay. And there's some of those classes are pretty extensive, right?
That's right.
In terms of so give an example.
Class 16, for example, is printed publications. So that's going to be newspapers, newsletters, books, anything that comes on physical paper. Most of the classes are for goods because originally trademarks were used only in connection with goods. But there are also now service classes, and that covers things like 42 covers electronics, computer software, and websites. Class 41 is an educational services class. So things like trainings and courses and videos would all fall in that class.
Okay. So how many classes should I apply for? I'm out here thinking about this mark, right? How do you decide the classes you want to go for? Do I already have to be active with some of these things like a printed newsletter, which to me sounds real 1980s, right? How should I think about that?
That's a great question. So at the federal level, I should say that to qualify for federal registration, which is what we want if we do qualify, you have to use the mark across state lines. So you're dealing with customers outside of your home state. If you do meet that requirement, the federal office allows you to apply based on current use. You would give an example of how you're using it. You'd give a date of when you first used that mark in commerce. Or you can apply on what's called an intent to use basis. And for a small additional fee, you can get your mark in the queue and considered by the trademark office and have feedback on it before you ever have to prove use. But it won't register until you are using it in commerce.
Got it. And this is where timing is important, right? You really, if you're serious about this, you want to go get in line.
Yes, that's absolutely right. And we're dealing with a government office. There's a lot of interest in trademarks over the last few years. In particular, applications have gone way up and the time is considerable. They're saying somewhere between 9 and 12 months for initial feedback on an application.
Yeah. So if I don't have what I think I can trademark, should I invent one? Should I come up with one? Is it that valuable to have?
I think it's valuable to be able to differentiate yourself from others in the marketplace. Many service providers want to use their own name and they're out practicing under their own name. And in that case, I would say it's not worth trademarking. Right? Your name is distinctive. You practice under that. That's great. But if it's a different brand, if it's a different explanation or indication of what it is they do, we want to ensure that the service provider can continue to use that and that somebody in the next county over isn't going to see it on social media and think, I like that. I'll start a business with that name.
Right.
I should say, I think this is an important distinction that people don't always recognize, that just because the Secretary of State will give you a business name does not mean that it's protected and doesn't mean that other people can't pick a name that's extremely close.
Right.
So long as it's not identical, the Secretary of State is going to give the name.
And then does it work vice versa, that just because there's another business out there with that name, would that preclude you from getting a trademark for that name? Or does it depend on how they're using it?
Exactly. It depends on how they're using it, if they're using it in a trademark sense. And it's also a question of whether they've registered. Okay. So we went through this process, and you said it's 9 to 12 months, and there is a patience piece of this too, right? And it takes a while to get your act together and get what you need to have filed, and it requires something of you, the client. It's not just all your attorney that does all this, right? So let's talk about what's required from the client perspective. What do you need to bring to the table to help your attorney out on this? Sure. So they need to come with a trademark. I went to law school because I'm not particularly creative. I like, give me the rule and I'll follow it.
Okay.
But I'm not a marketer.
Okay.
I'm happy to give my opinion as consumer out in the world. What would I think of your mark? But the client really does need to come with at least some suggestions that we can work from.
It helps to have been in business for a while, right? Because you know at that point after several years in business where you're differentiated, whether it's an accountant with a personality or whatever that mark is. The market sometimes tells you what it is, right?
That's true. That's a really good point.
Yeah.
Yes. And you may refine it.
Yeah.
And something to be aware of is that you have protection for the mark in the form that it's registered. So if you might be making changes to it, if you don't really love your logo and you're going to redo it next spring, let's wait until you've got it in the form you want to use it. Mm-hmm. And then we'd pursue a registration.
Okay. Now, one of the things you and I just talked about was, and I like the way you put this, you were saying the generosity mindset brand of products and services. So that mark has to refer to products and services in order to get the mark, right?
That's right. In order to function as a trademark.
Yeah. And that's where the classes come in, right?
Yes, that's exactly right. Mm-hmm. And so we tell the trademark office how we are or how we intend to use it, and then have to provide proof of that use before it will register.
Okay. So and this is what I was getting at in the introduction. It's not just the mark, it's how the mark is used.
Yes, that's right.
So in other words, you can't do a mark for you. Maybe can you do a mark for your name? If your name's unique enough?
You can in some circumstances. Okay. Yes, you have to give permission to use the name.
Okay. But that aside, it's really impractical to think about trademarking your name.
Unless you're famous.
Unless, yes. Right. Unless you have a one-word name. But that's really impractical. But what is practical is something that summarizes your way of doing business, your way of creating transformation for clients.
That's right. The name, the logo, the thing that the client is going to see and immediately think of you, that is absolutely worth protecting.
Okay. So let's talk about, I guess, I would think one question people would have is, John, this sounds like vanity to me. that I want to be able to go out there with my little trademark and have TM behind it. Why is this more than just vanity?
Trademarks actually serve to benefit both the business owner, who has a legitimate desire to protect what they've built and to keep others from trading on their reputation, but also the consumer, so that when your customer is looking for you, they know that they found you and not a cheap imitation.
I like that. You would expect me to like that one, right? I don't like the cheap imitation. So then there's an investment here. There's a return on that investment, one would hope. How do you think about it? Because we talked about the legal piece of that. How do you think about it from the business side? Because you're giving business advice to business owners about whether to pursue this. How should one think about the return on the investment of both money and time that go into hopefully getting a trademark?
Sure. And you're right. It is an investment, but one that I think business owners should give serious thought to for several reasons. One return is the prevention of problems down the road, right? Holding that registration is going to make it much easier to stop someone from using the same name or from copying your logo. That registration attached to a cease and desist letter is going to get action in a way that just saying I've been using it longer may not. Mm-hmm. It's also a significant asset that the business owner has to sell. If they're going to sell their business at some point, many small business owners hope to have that as an exit plan. If they have a protected trademark that the buyer can feel good about, that they know is not infringing, that's been registered for a couple years, that can really elevate the value of those brand assets that they have to sell.
What about the authority value, that comes potentially from that? Is there authority value that comes from having a trademark in your mind, in your experience?
I mean, I guess I can only speak for myself. And yes, when somebody has a Circle R following their trademark, I think these people must be serious. That or they don't know that they can't use the Circle R without having registered. So important note.
Right. They're going to the worst attorney possible themselves for legal advice.
No,
Yeah.
maybe, but here's a bit of free advice, and that is that anyone can use that superscript TM. There's no registration requirement. So it's a nice deterrent to go ahead and stick TM on the end of your mark, which indicates that you believe you have trademark rights to that name.
Okay, and that's a great point, because speaking for myself, the advice you gave was to go ahead and use that, right? The TM, and then you use that for, let's talk about the sequence of how those marks get used.
Sure. At any point when this is your trademark and you want to assert rights to it, you can go ahead and put that TM on there. You cannot use a Circle R until you receive a registration from the trademark office for that name, logo, tagline. So part of my congratulations communication to my clients when we receive those registration certificates is now you can go ahead and switch from a TM to a Circle R.
Got it. And again, that's in that particular class, whatever you've applied for, right?
That's right.
So you cannot I can't use the generosity mindset for the latest line of swimming equipment that I want to put out.
That's right.
That has nothing to do with what I applied for.
That's exactly right.
Okay. So again, I think there are business owners that don't know they have intellectual property, and then there's some that think they've got more, and I want to get to them in a second. But the ones that don't really think they have something, what do they need to look for? What do they need to look for in their business that says, maybe I need to develop this and flesh this out a little bit more so that I can go in a direction where I can get this get something trademarked?
Mm-hmm. That's a great question. I guess I'd back up just a little bit to say that there are 3 categories of intellectual property, and all businesses will have at least some of these. Trademark, which we've been talking about and which protects the brand. Patents, which protect inventions. And then finally, copyright, which protects materials that are created, blogs that are written, or pictures that are painted, or any creative works. So most business owners are creating copyrightable materials all the time. And they own that copyright merely by creating them, by writing their training materials, or by drawing diagrams that they're then going to share with their clients. So all of those should be marked with a copyright symbol, which is the C in a circle,
okay,
along with the author, the owner, and the year of creation. But in terms of looking at...
Let me stop you there for just a second, if you
Sure.
don't mind. I can do that without having to get to file on that. I create my material, and then I just use name, date, and the little C.
Circle.
C in a circle.
Yes, that's
and
right.
I can just do that without having to go file anything.
So there is a registration process with the Copyright Office, and it is important if, say, for example, you'd have to pursue legal action over infringing materials. But no, you don't need to register in order to use that designation.
Mm-hmm.
And I think, like the TM, it's an important deterrent for people to realize, oh, I can't just copy and paste this.
So, for example, in the beginning of my book, there's a little C in a circle.
That's right.
Right? And I didn't have to go to register anywhere. It's like what I'm saying by putting that in right there in the beginning of the book is, hey, this is my material, and you cannot go copy this indiscriminately without credit, right?
Absolutely.
Yeah. And I didn't have to go as much as you might have wanted me to come get my help, help me register for that. I didn't have to do that, right?
No.
So it's the material you create. You don't really have to go through some process.
That's right. The copyright arises merely by creating it. And so I tell people that there's no dire need to register unless they want to, unless an issue comes up with infringement.
Okay. So back to the people that need to think about what they see in their practice that needs to be marked. Any other thoughts on that?
So we talked about trademark, or excuse me, we talked about copyright.
Right.
If you think that you have an invention, something that's novel, that's new, you need to work with a patent attorney specifically, and they can give advice about that. I only know enough to be dangerous, but that includes the fact that there are very strict time limits. So you don't want to be out offering your product for sale, for example, without having talked to a patent attorney and locked down those rights if possible. But as business owners are looking at their business and thinking about trademark, they need to consider what words or what symbols do my clients see that I want them to connect with my business and the services I offer. Some of the questions that I'll ask to try to get clients to think about this is, if you had to rebrand tomorrow, how difficult would that be? How upset would you be?
Right.
If you had to rebrand tomorrow because somebody else registered and had prior use and is able to stop you?
Got it. That makes sense. So let's talk about those business owners that come to you that maybe they think they've got intellectual property that needs to be protected, but they really don't. Now, we've already talked about descriptive trademarks, right? Are there any other examples that you can think of where everybody needs to consult their own legal counsel? However, that they really don't have the protection, or they don't have something that can be protected in the way they would like.
Along with the descriptive marks, I will occasionally talk with people who come up with a phrase, for example, that they want to use, and they want to keep everybody else from using those 4 or 5 words in this phrase.
Okay.
Right? Trademark law does not allow that and doesn't want to allow that. It's not supposed to make words off limits. Instead, the trademark law protects businesses and consumers by saying you can't use these specific words or specific logo in connection with these services or these goods. So we have a conversation around the classes, around the idea that there can be multiple identical trademarks even for different things. That's why there can be a Delta Airlines and a Delta Plumbing, because nobody's going to confuse those two and think that the airline company is also supplying their faucets.
Great point. So you figure out the classes that you want to apply for, and I presume that the goal should be to apply for more than what you think you're really going to need. If you've got time to figure out whether you're going to use that or not, right?
Yes. I would say that on an intent to use application, if we're not sure yet how exactly the mark will be used, it's better to go broad. We will have to either show use for these things or delete them from the application in the end.
Okay, let's talk about the timing on all that.
The intent to use application is very useful because it goes through the process. The trademark examiner is going to review it. They're going to make sure that there aren't any conflicting marks already in the record. There's no descriptiveness problem. The trademark examiner is going to say, we're happy with this. They're actually going to go ahead and put it through the publication period, which is a 30-day period when it's used to be published in a printed gazette. Now, of course, it's available online, but that gives third parties an opportunity to object to a name that they may think infringes on their rights. Once that period is over, the trademark examiner says, okay, now show us how you're using it. And so you have 6 months to do that. And once you've satisfactorily shown, then the mark will register. So it's nice that all of that work, as far as getting it reviewed and everything, happens up front. And that gives the business owner time to get their ducks in a row, to start rolling out their mark, to get that use happening.
Got it. So you know what you do know what you've applied for. So you, not just when you get that preliminary approval, right? You've got this 9 to 12 month period of time that you can get your act together.
Exactly right. Yes.
To use a technical term, right?
Yes.
On how you're going to use this and clarify that in your mind.
That's right. And that's a great conversation to have with your trademark attorney, definitely before it is filed. But in those initial conversations, how do you think you'll use it? What are your plans? How will you show use of the trademark with your customers?
So as we wrap up here, and I want to get back to the return on investment here, right? Because this is not an overly onerous process from a time point of view. There's not really, compared to a lot of legal issues that you have to deal with, this is not, at least I didn't find it to be a major drag on my time. Mm-hmm. And from an investment point of view, it strikes me as being something like a monetary investment. It strikes me as being something like an oil well, where you drill and you may get a gusher, you may not, but you really haven't. If you don't, it's not like you've bet your company on it. The investment is not so much that you bet the farm on it.
I think you're exactly right. And it gives the business owner the confidence to know that this mark is protected, that they're not going to have to throw out the 40,000 brochures they just printed and change everything tomorrow. Mm-hmm. And I think that's very valuable. Along with the search process itself, knowing that your mark is distinctive in the marketplace, for example, there's a lot to be said for knowing who else is out there doing similar things, and is your mark distinctive enough, or are you going to be lost in a sea of similar marks?
So you end up getting your trademark, and you get the congratulations letter from Katie Moore.
Use your Circle R now.
Yeah, yes. Use the Circle R. So how do you protect now? And how do you protect that mark? And do you have your attorney continue to look out and see if there are unlawful uses that are going on, or how does that work?
Well, you certainly can. And large companies would certainly have their attorneys on that, because there is a duty to so-called police your mark. Mm-hmm. You have the registration. You have to make sure that other people aren't out there using the same or something confusingly similar. There are renewal obligations, so you have to continue using it. This is something really important that I try to stress with people. You need to continue using it in connection with those goods or services that you're registered for, but also using it in the same way. So if you add a new element, if you add a new word, that could potentially be a problem when we come to renewal time. So you want to reach out to your attorney if you're going to make changes to your mark after it's been registered.
Got it. So is this this self-policing you have to do, how onerous is that for a small business owner? It's got all these other things going on in their business, and it's hard to think about that, right?
Sure.
So how onerous is that for them to do?
I think it depends on your level of comfort with risk. You can have your attorney keeping an eye on it. There are services that'll do what they call a watch service. So you input your mark and pay them a fee, and they'll keep an eye on the Trademark Gazette as things are published. But I think for most business owners, just keeping a reasonable eye out on what's happening in connection with your name, with your logo. When you do a Google search of yourself, are you going to pop up there, or is somebody that now is using a confusing name? Reach out to your attorney if that happens, to get an idea of maybe when this person started using it. Maybe they've only recently started using the name, and so now you can reach out and say, I have this registration. You can't do that.
Well, Katie, this has been great, and I can't thank you enough for all the help you've been to me. So,
my pleasure,
yeah,
John.
You've been terrific. And I know people are going to find this of value. Before we get to your contact information, is there any other thing we've missed that we need to make sure people know about in this process?
The trademark law is complex, and it's not always intuitive. So I would encourage people to feel free to ask questions, to reach out to an attorney to talk with them, whether it's something that you're going to do immediately or you want to plan and budget for. I think it's well worth the time.
Great way to end, except for one more thing, which is, I think, the most important thing, how folks can find you. Okay. Yeah, they want to be in touch and explain their own personal situation and their situations unique to them and see if it's a fit. in terms of going through this process. So let's give your contact info.
I appreciate that very much. Thank you. My website is KatherineMooreLaw.com, and you can reach me by email at katie@KatherineMooreLaw.com or by phone at 770-872-0190.
Katie Moore from Katherine Moore Law. Katie, thank you again so much.
Thank you, John. I enjoyed it.
Yeah, me too. Thank you again. And thanks for your work. Hey, folks, just a reminder, if you don't already know, and I think you do, basically, if you've listened to this whole entire podcast, I've got a book out. It's called The Generosity Mindset, A Journey to Business Success by Raising Your Confidence, Value, and Prices. If you're having issues around value, how to express your value, adopting a mindset of value, pricing your services more effectively, proposals, and other essential elements to growing your services practice, I wrote this book for you. And you can find it where all fine books are sold, as the old saying goes, but you can also go to thegenerositymindset.com to learn more. And if you'd like, you can email me directly. Feel free to do that. My email is john@johnray.com. Thank you for joining us on the Price and Value Journey.